Let me start out by saying this. Iowa workers and Iowa employers deserve state government services that are delivered in a fair and impartial manner. And I think that's one of the things that makes our state great and our country great. Unfortunately, we have a problem in our state. I believe the Branstad administration has and continues to violate federal laws requiring the fair and impartial administration of unemployment insurance benefits. In the last few weeks, I've started to hear disturbing evidence about the fairness and impartiality of the legal system involved in Iowa unemployment claims. Senate staff and I have met with a number of administrative law judges, and here's what we've learned so far. In Iowa workforce development, there are federally funded administrative law judges who rule on disputes between employers and employees regarding unemployment claims. Under normal conditions, these judges are overseen by a chief administrative law judge. And according to the Department of Labor investigation and a letter regarding a similar problem in Maine, the Department of Labor states this: under federal law, unemployment compensation appeal hearings must be fair and impartial, both in fact and appearance. Political interference or undue political influence, even the appearance, can potentially destabilize the appeal process, undermine the credibility of a state's unemployment compensation system. That's the problem here in Iowa today. Teresa Whaler, a Branstad political appointee, is the director of Iowa Workforce Development. She is pressuring the judges to rule in favor of employers against employees. And some of her actions include these: demanding tallies of how judges were ruling, specifically how often they ruled for employers and how often they ruled for employees. Director Whaler demanded judges create tip sheets to help employers win their cases. And most significantly, she fired the chief judge and has put herself directly in charge of administrative law judges. Under normal conditions, these judges are overseen by a chief administrative law judge. Keep that in mind. Here's what I think should be done. First, I'm asking the U.S. Department of Labor to help investigating if federal dollars are being misused. And I've sent a letter today to the Department of Labor requesting an investigation, and you should all receive a copy of that letter. Second, I'm asking for Governor Branstad to ask Director Whaler to resign. Enough is enough, and it's time for her to go. So at this time, I guess, we do have questions. I'll see if I can answer them for you.
Who are the administrative law judges you've spoken to?
I care not to divulge that at this time because they're under real fear of reprisal by Director Whaler.
So
they're living in pretty much terror in that department.
They're all still current?
Some current and some former.
How many are currently in the department?
I think there are 14, and I've spoken with more than a majority of them.
When did she fire the chief judge and put herself in charge of the ALJ?
I think last year, sometime.
Who was that person?
That was Joe Walsh.
Can you say more about these tip sheets?
Yes, Director Whaler has requested when there were hearings that were ruled in favor of employees, that the administrative law judges create a tip sheet, as she called it, to help employers win cases, similar cases. But she has not asked for similar tip sheets for employees who might have lost their cases.
Any information on what may have been on the tip sheets?
I think that most of those, the administrative law judges were very concerned about entering into some type of political process, and for the most part, they tried to take language directly out of their rulings to satisfy the director's request. And in more than one instance, she said that wasn't good enough and asked for additional information. So I don't have those tip sheets in my hand, but in speaking with the administrative law judges, that was direct testimony from them to me.
You said that they were asked to keep a tally of how they decided their cases. What was done with those tallies?
That was asked of the chief administrative law judge. He refused to do it, and we do know in a short period of time after that he was removed from his position.
Do you think the governor and lieutenant governor were aware of this
I don't know if they were or not. The buck always stops at the governor's office, so if he wasn't, I believe that was his fault.
Do you think this is symptomatic of the administration's method of handling?
I have seen a pattern in the governor's administration with this and in other branches of, that I'm very much aware of. I have been following these problems with Director Whaler since the very onset. She has gag orders out to her employees and not being able to speak with anybody. In fact, the administrative law judges that I contacted were very fearful of even speaking to me and said that I had to sign a form that would be sent to the director in order to get permission to talk to the administrative law judges. I informed them that it's my duty as chairman of the budget on workforce development and economic development, that it's my prerogative to have oversight of that department, and I would refuse to sign any such form. And if they felt that their job was in jeopardy, then maybe they shouldn't speak directly to me. But they were so concerned about what was going on and the pressure that they felt was laid upon them by the director that they were willing to speak with me. But they made it very clear that I was the individual that requested this meeting and not them requesting it of me, and that is the truth.
Could you give us a time frame? When did you start hearing about this? When did you start?
I started hearing about this last year out of session. I've been hearing about problems in Iowa workforce development, about hostile work environments from almost the first day she took control of the directorship. But just most recently, in the last month, we've really sat down and met with administrative law judges, and I think that their response to me kind of paralleled what they viewed this case in Maine to be, because there were similar allegations, and it was upheld, and it really clarified what they felt was undue pressure on the administrative law judges. They are working very hard to try to ensure that they are making, and made very clear to me, that they are not letting these pressures try to influence their decisions. But when your job's on the line, it's a scary thing for them.
Just to be clear, this case in Maine was settled. The U.S. Labor Department ruled in favor of the workers?
Their ruling was that the governor had unfair or improper influence on the administrative law judges, and the Department of Labor laid out corrective steps to do that, to straighten that out. And from that, some of the language, what I've read today came directly from that Department of Labor report, and I think that that's going to be made available to you. It's online right now, but we're going to make that available, and also supporting documents of some of the emails will be made available to you through the Senate online.
There's a link at the bottom of the letter to the Labor Department.
Okay. because we have a lot of documents that are been handed to us.
Can you give us an idea of how many people have appeared before these administrative law judges in the past year, and what a case is like? I mean, talk about the people who are affected by the decision.
Well, I can't give you those direct numbers, but the cases are mixed there. When you file for unemployment benefits and let's say you're laid off or you feel like you were terminated, unfairly, Iowa's an at-will state, so we have Iowa Workforce Development. Their first line workers will determine whether you qualify for unemployment benefits or not. And if you were let go for just cause. And if it's ruled in favor of the employer or the employee, and they don't feel that that's a proper result, they have the ability to then appeal to the ALJs, administrative law judges, who are attorneys. And they are supposed to look at these cases in an unbiased way, directly dealing with the law. And as the Department of Labor says, they should not have political influence, and they should be separate as we separate the judiciary from any other branch of government. And that's where the director has crossed the line. She is, as a political employee, putting undue influence, has removed the buffer, the chief administrative law judge, from office and put herself directly as a supervisor of these administrative law judges, which is clearly in violation of labor laws in the Department of Labor and dealing with the Employment and Training Administration.
Do you have evidence that these cases are being decided differently, or that more have gone in favor of employers? Since
No,
this
I think
change?
that's why the administrative law judges have come to us. They have felt so much tremendous pressure, realizing that they feel like the director is pressuring them to rule in favor of employers versus employees. And I believe they've done everything in their power to maintain their impartiality and look directly at what the caseload is.
What would the motivation be on the part of the administration? I mean, why would they want employers to win more than employees? I mean, what do you think that would be about?
I think that there's a clear-cut belief that employees are wrong, and when they get terminated, maybe they shouldn't get unemployment benefits because we have the Unemployment Insurance Trust Fund, and one of the political arguments have always been that employers feel like maybe they're paying too much into it. So if you can deny benefits to workers that they are entitled to, the Unemployment Insurance Trust Fund is probably a little higher, and employers and companies don't have to put as much into it. It's a clear bias against working men and women in the state, and it's time it's over with.
Senator, you said that she eliminated the position. She actually eliminated the position, she didn't just fire the guy?
She fired him and then assumed his role as direct supervisor over him.
Is there any regulation or rule that would require that there be a chief administrative judge? I mean, is she breaking the law there?
I believe that she is violating the law because she has interjected a political employee, a political appointment over the administrative law judges, and that's her. That it's very clear that we have to have separation of the judicial process to have fair rulings to employers and employees. And she is not doing that. There was a buffer. The chief administrative law judge served as a buffer between the director and the administrative law judges that are hearing these cases. And she spoke directly to that administrative chief judge. Well, when she removed him, because apparently she didn't like the fact that he wasn't willing to keep a tab on which administrative law judges happened to rule more in favor of employees, she didn't like that, so she removed him.
Did you speak with Director Waller at all?
No, I haven't.
In answer to Kay's question, Sue says that each of these administrative law judges hear 26 to 30 cases a week.
And I believe they told me they're working nearly 60 hours a week now.
26 to 30 cases a week,
Correct.
each one. Have you heard the response from Teresa Waller this morning.
What was her response?
She said that, that Department of Labor completed a 3-day visit last week and will be releasing a report that does not contain any findings, and that the monitoring staff was very complimentary of the departments and improvements and process changes. And she says she's proud of what they have done, and that since August of 2013, Iowa has moved from 47th lowest in the country to 12th place in terms of the measurements of how the program is operating.
I would believe that'd be very true, because if you're working 60 hours a week, your output's going to increase. And I really believe that we have some of the best administrative law judges in the country. They're concerned about their rulings. They want to be not feel pressure on them to rule one way or another. They're living in fear of their jobs. Most of them are afraid of what's going to happen now that they've come forward and expressed this. And I'm deeply concerned that there will be retaliation against these administrative law judges, and I'm serving notice to the director to leave them alone. According to federal law, they are supposed to be isolated, and they shouldn't receive undue influence from this director, whether it's real or perceived. And I want to tell you something, it is real, it is not perceived.
If these issues have been ongoing for a while, wouldn't the Department of Labor have recognized them in the monitoring that they just completed?
They asked me about when they knew the Department of Labor was coming, and they asked me if they should report directly to them about what was going on. And I said at this time, I prefer that we talk directly to the head of the Employment and Training Administration, and we sent that letter to them, and rather have them investigate directly with the evidence that's presented. So I feel that they haven't spoken up because out of fear of what the reprisals can be to them, and they clearly withheld, that information, or at least didn't disclose it to the Department of Labor people, who are really looking at the cases and reviewing the cases on whether they're impartial or not, and looking at their workload and how much are they doing.
Senator, should we assume that this position that she fired the guy, Chief Administrative Law Judge, has that always been an at-will position?
I believe that was a merit position, and she eliminated the position and then removed the individual.
Is that W-A-L-C-H, Walsh, or is it S-H?
SH.
Is there any chance you'll be able to call Teresa Waller before lawmakers or subcommittee?
I would hope that that's something that occurs, and we're going to be discussing that. I think there's clearly enough evidence to warrant a further investigation.
Will Oversight Committee?
That's their normal role, so I'm going to be talking with the chair of the Oversight Committee and our leadership. I know they've got plenty of work lately, but it's important that this stuff comes out and we maintain the impartiality of these administrative law judges, whether it's for employers or employees. If we had a Democratic governor in there, we would not put up with undue influence on these judges to rule in favor of employees. We need to have a fair system in Iowa, and Iowans believe in fairness. And the impartiality of the judicial system is key, and the director has clearly stepped over the line.
You have time for one more question?
Senator, I know this isn't your key concern,